Welcome, everyone, to another installment of Workplace Matters. I'm Henry Roman with my co-host,
Diana Castrillon. Good afternoon.
We're here at the Palatial Broward County Bar Association studio. We got two special guests today.
Thank you.
They're so special.
They're so special.
That Henry literally lost.
I can't even believe that I have these two gentlemen here today. I got sitting judge Tom Hedler here from West Palm Beach, who made the long trip down to join us.
Thank you.
And
for doing
obviously
that.
we have
Obviously.
Yeah, obviously.
I'm an obvious.
yeah
You are.
Howard Sheiner,
You're so obvious.
private mediator. No, I tease them both. No, we're very proud to have you both. So thanks for coming on.
Thanks.
It's been a little bit, Diana. What have you been up to?
Yeah, it has. Well, I'm just excited that we're doing this again, and we're trying this as a new platform or a new style where we actually have guests interacting with us, because I think you guys are sick of hearing and looking at Henry and I. I mean, we certainly are. So
I am too.
Agreed. So I mean, I'm hoping that we brought some better looking faces to interact with you guys.
Sure of it.
Certainly more
And,
informative.
we'll see what happens. But no, we since we have a unique opportunity to have a sitting judge and a mediator here with us, and we all know that motions to enforce are such a hot topic, right? This is something that, at least over the last since COVID, right? 4 years, 5 years, we've seen this huge amount of motions to enforce coming up in our practices. And so we thought how great to hear from the mediator, who's, probably being blamed for most of these.
In the room where the sausage is.
Exactly. And what the judges are hearing. So Henry, what do you think?
And we're talking about motions to enforce either mediation agreements or settlement agreements that are reached. I don't want anybody to confuse this motion to enforce something else. The reason why I bring that up is we were at a BCBA meeting, and someone was coming up to me and goes, "Oh yeah, motions to compel or motions to enforce responses to requests for production." I'm like, no, that's not what we're talking about.
Right.
We're talking about enforcing agreements reached at mediation or settlement agreements in general. All right, so let me just ask the question, Howard, you follow the cases, right? And would you agree that there's more motions to enforce now than maybe 5 years ago? When
Probably 10 times more.
And what do you think? What do you attribute that to?
If you go and look at the issues in the enforcement orders, I think they are mostly people who've decided after a period of time that they don't like the deal that was entered into. Now, that's not necessarily, when we're talking about this, that's not necessarily buyer's remorse. It's really, maybe they're not prepared appropriately for the hearing, for the mediation. Maybe they're not, the mediation is not treated with the importance that it deserves. We all say informal, it's informal.
Right.
And informal does not mean unimportant.
That's correct.
And let's discuss, obviously not formality, right? Formality is a very loose term, especially in the world of workers' comp and in the world of post-COVID workers' comp, specifically with the fact that mediations are taking place and they're not live. You're not in the same room with the parties who are making decisions. So I would imagine, and I have also noticed, this huge uptick since COVID. And I think a lot of it is because we're not all sitting down together. So how do you overcome that in mediation?
Absolutely. When a claimant is on the telephone and is being told they're settling their case for $60,000, $120,000, $350,000.
That's a big settlement.
That wasn't with Henry Roman.
For you,
just letting
right.
everyone know.
So that when they're being told that, it's not as meaningful as when they're sitting there and they're seeing the parties participate in it. And I think you have hit the nail on the head.
I usually
Post-COVID.
do, right?
Almost always.
So yeah, but go on.
So
You
you're
can
a
say it
carpenter.
again.
Okay. So when people are sitting down and they're coming to a mediation, they treat it with, even though not formal, with an importance, because they're there. They see it happening. When they pick up the phone and they're asked, "Do you want to do this?" they're not treating it as though it's as important. I think it's as important as the lawyers make it seem.
Right.
And post-COVID, there is a lot of, let's just get this done. We don't want to do Zoom even, so we'll go private, and that way we'll just do phone. And there are a lot of mediations where I get claimants in, they're unprepared.
When does that preparation start for either side? I know it's different, but lawyers got to prepare it either way when they're representing clients. When does that preparation actually start? Certainly, it sounds like not the day of the mediation. What do you think?
Well, I think that preparation starts when you take the case. For a claimant's attorney, it starts definitely the day you take the case, because you should be telling them this is the process that we're going to go through. And this process includes mediation and may include a settlement. Like, you have to do that for your folks, right?
Absolutely.
You got to tell them so that they know what most claimants want to know. How does this case go? Am I going to have to go to court? And when you tell them, well, you may not have to go to court, maybe we'll have a mediation, and they don't know what the mediation is, all they're thinking is, okay, so I don't have to go to court.
And Judge, when they're showing up in your courtroom and you're taking evidence from these claimants who are telling you in court, I didn't understand what I was doing, or giving some other reason. I mean, what are you finding is the big reason? What is the main reason that claimants are feeling that, I'm asking specifically claimants, are feeling that an agreement wasn't reached?
Well, I mean, the vast majority of the problems with motions to enforce are based upon the claimant, certainly. There are some injured workers that you could tell pretty quickly this is truly a buyer's remorse.
Right.
They talked to somebody after the fact, was told they should have gotten a lot more money, something along those lines.
The all-knowing brother-in-law, perhaps.
Yes, absolutely.
Everybody's got a sister's cousin's uncle from California.
But there are a number of injured workers that I know I've had hearings with, because I have granted a number of these motions to enforce, but I have denied a lot of them. And it's because I oftentimes get compelling testimony from the injured worker that they truly did not know what's going on. I know we are around this table and we're saying post-COVID. And I think that is the driving factor of the more recent iteration of motions to enforce. But I think COVID just revealed, I think, probably the bigger problem, the underlying problem, and that's the problem that you're referencing, and that is there's no preparation. What we're seeing in the practice, and we're seeing it across the spectrum, it's not just settlement and mediation. We're seeing it in the quality of the pleadings that are filed, silly mistakes, overlooking this, not giving you that. The practice is running.
Can we call
so
it
fast.
what it is? Cutting corners.
Is it cutting corners,
Yes.
though, or is it just too many people are working off of a business model of volume? And
That's
so
cutting, but it requires cutting corners.
It is. It's predicated upon the notion of, well, that's just cost of doing business, and so you take those deficiencies. You take that settlement didn't get enforced. Okay, well, you just move on to the next one. The fee wasn't approved. Move on to the next one. There's too much volume, and we're seeing it in all aspects of our practice and in a litigation of our practice. And so when you've got that mentality and you've got a quick prep with injured worker, what I've been seeing just through hearings and testimony is the injured worker, many times there's not a live initial consult. There is a phone call. We're going to send you settlement or a retainer agreement package. You review that, you sign it, you send it back to us. Then you'll get an initial conference on the phone with a lawyer. Then they do their deposition. Maybe there's a telephone conference before the depo. Maybe there isn't. The depo, maybe Zoom, maybe phone, oftentimes not live. Then maybe a phone call before mediation, maybe not. Maybe just before mediation starts. Then for a long time, we were doing only mediations by phone. How are they going to understand exactly what they're dealing with when you can look at a list of other lawyers in the Broward County Bar Association that wouldn't understand what we deal with on workers' compensation? We're expecting these unsophisticated injured workers to comprehend that through a series of phone conferences. If we're not meeting with them live at the initial, live pre-depo conference, live pre-mediation conference, mediation, come into our office and let's meet, and then let's go on the phone or let's do
It
Zoom.
would be easier to do Zoom in that circumstance too, because sometimes
Sure.
claimants don't have the technical
technology.
know-how to do Zoom. But
Sure.
if they're in the attorney's office, that would be easy. I've had, in this kind of cutting corners idea, I've had a lot of attorneys who get annoyed with the fact that I do an opening for claimants.
Why?
They don't want to spend the time. They feel like, well, I've already told the claimant what they need to know. Well, but my role's different than theirs. My role's the independent role.
Right.
And they should actually hear that from the independent, not from their own lawyer. And that's more of the same kind of, they want to get this done with, but they're going to spend the time later on if they don't spend
Right.
the
That
time
goes
now.
back to my overall point is the lack of preparation, I think, is really the problem. For
Yeah.
many, I've had claimants attorneys tell me that because so few of these cases actually go to trial where there's some finality, right? Because our final hearing is a misnomer. It's just it's only final for those claims that are there. The case could go on forever. But they tell me this is their day in court. And that's why it's important for them to go to mediation. And then we go to mediation, and it doesn't seem like it's that important.
You were saying what tips can you give to the practitioners? Treat it besides the preparation, treat the process, even though it's an informal process, treat it with the importance that it deserves. Make sure they understand that they're participating. This is a great opportunity. I'm going to sell mediation for a minute. This is a great opportunity.
Take two, please.
Because our society has been trained that the best way to resolve problems is to have some independent third party decide it for you. And we've accepted that for many years.
Well,
I think we're
mom and dad, right? If you don't get the result from
Sure.
mom, you go to dad. Somebody's going to make the decision for you.
Sure, maybe not exactly what democracy is all about, right?
Right.
But this is our opportunity to exercise judgment. We don't, and that's why I think alternative dispute resolution is making a big wave, because it's an opportunity for people to be involved with their own decision making. They can participate in the outcome of their case. So treat the mediation process with that kind of reverence that we treat court with, but it's a less formal process, but still as important because that same decision is being made. It's just the participants are participating in it.
Right, because that mediation agreement has legal consequence, whether it's an impasse or an agreement on the claims that have been asserted by petition, or even better, settlement. So it should have that reverence, like you refer. I like that.
And you just brought up another point, for practitioners, the final product. And what we were talking about, by the way, in fairness, goes to defense attorneys as well.
It
Because
should.
There are plenty of defense attorneys who I don't speak to their clients until the very last minute when they need to beg for additional money. And here I have to be the sales manager at the car dealership to sell, oh yeah, this is a good deal. This is why it's a good deal. Well, maybe you should have had me involved in that process a little bit earlier.
Right.
But then the mediation agreement. A lot of people get very tired at the end of mediation and they feel like, all right, you just go write that up and we'll sign it. No. That's a pretty important document.
Absolutely.
It's probably the most important output of that entire event.
Right.
And without it, you don't have a binding agreement. So, you got to be willing to put the time in to prep them. You got to be willing to put the time in to treat the process with the reverence that it deserves, and put the time in to go through the actual drafting of the document.
And how about the signatures, right? That's a big question now, because a lot of stuff is being signed electronically, because obviously we're not live for state mediation. We're all via Zoom. They use that Sign Easy program, which is great. But, realistically, it's not going to the claimants. Do we see, and Judge, maybe this is more of a question for you, is there any discussion about, now we're getting claimants' emails on DOA when the cases are opening up? Is there any discussion, happening about where maybe claimants are going to receive that document to sign it through Sign Easy or some format?
I don't want to speak for Judge Langham, but I am under the impression that there is a lot of discussion with respect to that, and they do want to move in that direction. I don't know why you couldn't utilize it even without having their email registered with DOA. You have their emails, you can forward
True.
it and get that done
Agreed, yeah.
on your own. But I think that's absolutely something that the state mediators would like to have. They want to have the injured workers and the carriers sign off on these things,
Yeah.
because
Agreed.
they don't want to be dragged into this situation where
Agreed.
their mediation is being thrown into doubt.
Yeah.
And I use DocuSign, but sometimes in a lot of cases, actually, the claimants don't have the ability to either do it or have the wherewithal to do it. And I always recommend to the attorneys that from the claimant's perspective, obviously, because that's where that goes wrong, that they get something in writing, whether it be an email or a text message, where they actually show them what the terms are and get an okay to it.
It's interesting you bring up some claimants, I guess, and on the other side we may have that too, although not as much, not having the technical either ability or just the tech to handle something as simple, right? Of just signing a document via whatever, one of these DocuSign or whatever. I remember early in my practice, mediators, particularly on the private side, as part of the notice for private mediation that we would file, they would request an actual statement of the claim, statement of the issues. I'm wondering if we should go back to something like that, wherein one of the questions that we have to answer is, how are we going to transmit this potential agreement to your client? Am I going to have to rely on you? Do they have a separate email address? In other words, what we're talking about, more of the prep up front, that way we don't run into these issues on the back end. Because if we don't have time to prep, presumably, we don't have time to prepare for a motion to enforce hearing, and that's not good. If we can do it right at the beginning, we avoid these unnecessary hearings or hearings that just aren't really necessarily required.
So all of this is the time spent put in to make it work. All the things we're talking about is being willing to put in the time.
But what do we do? How do we encourage practitioners on both sides to really
Isn't
think
it better to deal with it before than after, right?
Judge Hedler likes us to go to his courtroom, so maybe he prefers dealing with it afterwards.
But if
All
you-
kidding aside, though, I would,
Happy to do that.
yeah.
That's what
I'm
here
sure.
for.
I'm sure you don't like, or maybe you don't have an opinion either way. But as a judge, I'm putting my judge hat on for a second. I wouldn't want to be put in a position to make those kind of determinations. I mean, this is a mediation agreement that the parties worked hard, presumably, to reach a consensus result, and here we are trying to undo what the parties did a month ago, 6 weeks ago. How does that make you feel?
I don't have an opinion one way or another. I don't care what I'm adjudicating. So for me, if the dispute is I didn't agree to settle, I was coerced, I didn't fully comprehend, I didn't voluntarily give authority to sign on my behalf, like, I'm fine with that, as opposed to anything else. It doesn't matter to me. What I see very frequently with the motions to enforce, when they get to that stage, is you're alluding to this as well, and that is the lack of prep has just continued.
And you're at a disadvantage, and from your perspective
And
as
most
the
times
judge,
I am, yes.
because you don't know what goes on in the mediation.
That's right.
Nor can you find out.
That's right.
Well,
Or can you?
That's interesting. How do you feel about mediator now witness in one of these motions to enforce? I mean, is there any ethical concerns that you have? Is there any statute on point that talks about perhaps privilege that we have to worry about?
Of course, there is a statute that says that mediators should not testify. I disagree with the judge on his interpretation of this. The judge believes, well, I don't want to speak for you.
No, go ahead.
No,
We've had this discussion.
No, you speak for yourself.
So, Judge, what is your thought as to whether mediators can testify at motion to enforce hearings about the specifics?
I think if everyone agrees, they can testify.
But other than that, would there be ever an opportunity where a claimant may waive their
The
confidentiality?
statutory privilege.
It's not just about the claimant, though. Everyone has to agree. your client has to agree as well.
Absolutely.
So everyone has to agree or it doesn't happen.
So question, sorry.
No,
No,
go
this
ahead.
is-
This is your
So-
show too.
So let's say you have the agreement of the claimant's attorney,
Mm-hmm.
the agreement of the defense attorney, and the agreement of the
The parties.
the employer and carrier. The claimant does not agree, but is the one seeking to overturn the agreement and gives testimony about what the claimant believes occurred at mediation. Isn't that a waiver by the claimant of that privilege?
You mean that testimony's coming in without an objection?
Yeah.
If it's coming in without an objection, it's going to be heard. There should be an objection if they didn't, waive confidentiality and then they're going to breach confidentiality. I would like to think there's going to be an objection to that. If there's no objection, the testimony continues. I don't know that it's my role to step in and stop that at that point. That's why these parties have
then
capable
why would-
counsel.
Then can't the mediator testify after that?
If it's been breached, yes.
Okay. So, and to answer, going back to Henry, the question you were asking, I do think that there are ethical implications because there are things that are shared with me in strictest of confidence.
But if those confidences are waived,
Yes, but they are shared with the strictest of confidence. And so I hold that ethically very tight. I'll let it go if the judge tells me to let it go, but without being told by the judge to let it go, that's not for me
Well,
to give out.
I guess one way to address that concern is the parties agree on the scope of the waiver, right? Like you can only speak to issues of
I don't
formation.
think there is
don't-
a scope.
I think when you open the door is
Once a
open.
privilege is waived, it's waived for all purposes. That's the case law.
Really, because in
Mhm.
instances, for example, the attorney-client privilege, when we're talking about statute of limitations, we can go into and ask questions about, did your lawyer tell you about the statute of limitations? That's permissible,
yeah,
but we can't ask them everything else that's happened in that case.
Because that's not a waiver of privilege. That's been interpreted as actually
Exactly.
admissible.
So there's case law that says that if you just ask questions about formation by agreement of the parties, but the mediators, it's fair game to ask them anything else.
Oh, and I'm speaking generally of privilege.
Right.
Generally with privilege, if you let it go for any purpose, you let it go
Right,
for
that I
all
understand. But
purposes.
I guess the premise of my question is the parties agree. The only subject matter that the mediator is going to testify to.
Like if they stipulate.
Formation, right.
If they stipulate to the parameters of your testimony.
I guess the parties could stipulate.
Sure. Well, that's what got them there to begin with, right?
Yeah.
That's true.
So I
That's
guess
the question.
I guess what I'm hearing overall and in summary of our conversation today, what I'm hearing is that in order for us to avoid these motions to enforce, which have undoubtedly increased over the course of the last 4 or 5 years, and we think in part due to the fact that a lot of things are just not occurring live anymore, that's just the reality of our practices, is that our preparation needs to look a little different. Our preparation needs to be perhaps even more thorough than it was before because these individuals aren't there with us. So making sure that the conversations are being had, that the questions are being answered well in advance, having the mediators communicate throughout the process with all the parties involved so that they feel engaged in part of the process. And I think one of the keys is that you said, it's an informal but not unimportant process. And I think that was probably one of the key things that stuck in my mind is don't allow the informality of the process to for any moment make the claimant or the carrier employer believe that this is an informal decision being made. This is when you make that decision, it's a formal decision.
It's a legal event.
It's
That's
a
required
binding.
by the statute.
Absolutely. I mean, you can be there voluntarily, of course, but once you've decided, that's a formal binding agreement. So I want to thank you, gentlemen, for being here and sharing your thoughts with us today on this
Thank you very much.
really
Thank you for
important
having us.
topic.
Thanks for having us.
Yeah,
Absolutely.
appreciate it.
Thank you.